Okay, so we're diving into the Negotiable Instruments Act of 1881 today. It's funny, most people don't even realize how often they interact with this act. Every time you use a digital payment app, write a check, or deal with a promissory note, this act is there working in the background. It's like the silent force behind so many financial transactions.
Really is foundational.
Exactly. And we've got some excerpts from this business law textbook chapter to guide us. I know, 1881 sounds ancient,
A little
really.
bit archaic, yeah.
But that's what makes this so interesting. This act has survived for over a century. Why? What makes it so important?
Well, at its core, it brought much-needed structure to how we deal with credit instruments. Before this act, business transactions, especially those involving credit, were a nightmare.
It's hard to imagine a time without it.
Right. It was like the Wild West of finance. This act came in and established the rules of the game, so to speak, making trade and commerce far more secure.
Okay, so let's break down a key concept. What makes an instrument negotiable anyway? It's not like we're haggling over prices at a flea market, right?
Exactly. It's all about the ability to transfer ownership smoothly and legally.
Like when we were kids trading baseball cards.
Precisely. That card represented a kind of value, and you could trade it, sell it, or give it away. Negotiable instruments work in a similar way, but in the world of finance.
So this act basically created a system of trust for promises to pay.
Precisely. And it's fascinating to note that India's act didn't just appear out of thin air. It drew inspiration from English common law, adapting those principles for India.
Interesting. So some of those legal intricacies might have a familiar ring to them. Okay, let's get into the nitty-gritty. The Act focuses on three main types of negotiable instruments: promissory notes, bills of exchange, and checks.
The big three.
Exactly. First up, promissory notes. They're like legally binding IOUs, right? So imagine I borrow money from you. Instead of just a handshake, I could give you a promissory note to make it official.
Right, and that unconditional undertaking mentioned in the textbook is key. It means there are no ifs, ands, or buts. That money's getting paid, no strings attached.
Gotcha. So it really reinforces that element of trust. Okay, on to bills of exchange. These seem a bit more complex. We're talking about three parties now instead of two, right?
Absolutely. You've got the drawer, who's ordering the drawee to pay a certain sum to a payee. And what's interesting is that the payee could be the drawer themselves.
Wait, so I could essentially write a bill of exchange to myself?
Yes, the Act allows for that kind of flexibility.
Wow, that's fascinating. Okay, now checks. Those familiar slips of paper we all know and sometimes dread. Those are technically bills of exchange too, right?
They are. But there's a key distinction. A check is always drawn on a banker and payable on demand. It's like having instant access to funds.
That makes sense. And here's where it gets really interesting, I think. That 1881 Act, it's been updated to include electronic checks, right?
Exactly. It shows that the Act, even though it's over a century old, has evolved with the times. It's incredibly relevant in our digital age.
All right, so we've covered some of the basics of the Negotiable Instruments Act. But like any good legal framework, there's some nuance tucked away in those pages.
Absolutely. The Act is full of interesting details.
Right. Let's decode some of that legal jargon, starting with bearer instruments versus order instruments.
Sure, it sounds complicated, but it's really about control and security.
Okay, I like where this is going.
So a bearer instrument is a bit like cash. Whoever holds it owns it. It's risky because if you lose it, anyone can use it.
Makes sense. What about order instruments?
Order instruments are linked to a specific person, offering more protection.
So like a check with my name on it.
Exactly. You need both a physical check and your endorsement for it to be valid.
That makes sense. Our textbook mentions that a promissory note can never be a bearer instrument in India. Any idea why that is?
Good catch. That's because of the RBI Act of 1934. After gaining independence, India wanted tighter control over its financial system. Restricting promissory notes to order instruments added that extra layer of accountability.
Gotcha. It's all about making sure those promises to pay are rock solid. Okay, next, jargon alert. Inland instruments versus foreign instruments. Is this as simple as it sounds? Geography.
You got it. An inland instrument is like a local train, drawn, payable, and circulating within India.
Makes sense. So a foreign instrument would be like,
An international flight. It might be drawn in India, but is payable in another country. Different countries, different rules, different jurisdictions.
Okay. Navigating a roundabout in London versus knowing your local traffic laws.
The perfect analogy.
Speaking of navigating tricky situations, our textbook talks about intriguing exceptions, and this first one, inchoate instruments, sounds a bit scary, to be honest.
Let's break it down. Imagine you find a signed check, but it's completely blank. No payee, no amount. That's an inchoate instrument.
Oh, wow. Okay, I can see where this is going.
It's incomplete, potentially dangerous. According to the Act, someone holding it could fill it out.
Wait, seriously, that's like handing someone a blank check, literally. What's stopping them from putting in a crazy amount and trying to cash it?
That's where estoppel comes into play.
Estoppel, that's a new one.
It basically prevents someone from going back on their word if they acted negligently.
So if I'm careless enough to sign a blank check...
The law might not be on your side. It pushes for responsible financial behavior.
Ouch, that's a harsh but necessary lesson. Guard those checks, everyone. Okay, what about ambiguous instruments? What are those?
Just like the name suggests, these instruments aren't clear. Is it a promissory note? Is it a bill of exchange? The lines get blurry.
Oh, no. So how do you even deal with that?
Thankfully, the Act provides a solution, specifically in Section 17.
Phew, that's a relief. Section 17 to the rescue. What does it say?
It gives the holder of the instrument the power to choose. They can treat it as either a promissory note or a bill of exchange.
Interesting, so they get to decide.
Exactly. But there's catch. Once they decide, that's it. No takebacks.
Ah, so you gotta choose wisely.
Exactly.
Well, that's reassuring. At least there's a system for these ambiguous situations. Now, onto a situation I'm sure many of us have dreaded. That awful moment when you realize a check you've deposited has bounced. But in India, it's not just an unfortunate mishap. It can be a criminal offense.
You're right. It's about upholding the integrity of financial transactions.
Wow, so it's serious business.
It is. Section 138 of the Negotiable Instruments Act deals specifically with these dishonored checks.
So Section 138, dishonored checks. When does it actually become a criminal offense?
Well, there are a few conditions that need to be met. First, the check has to be presented within its validity period.
That makes sense. How long is that, usually?
Usually 3 months from the date it was written.
Okay, so you can't just hold on to a check forever and expect it to be valid.
Right. And even if you present it within that time frame, there's another step. If it bounces, the payee needs to formally request payment from the drawer.
So it's not enough to just, like, give them a call and say, hey, this check bounced.
Right. It has to be a formal demand for payment, usually in writing.
Yeah.
And this demand has to be made within 30 days of the check bouncing.
Gotcha. So there's a paper trail right from the start, ensuring everything's above board.
Exactly. Accountability on both sides. Then it gets serious. Even after getting that formal demand, if the drawer still doesn't pay up within 15 days, that's where things cross the line.
Wow. Okay, so the act really gives the drawer every opportunity to make things right.
It does. But it also makes it clear that dishonoring a check isn't something to be taken lightly. And remember, rebuttable presumption. We talked about that earlier.
Right. So just because a check bounces, it doesn't automatically mean the drawer is guilty of a crime.
Exactly. They have a chance to prove that the check wasn't issued to discharge a debt or liability. Maybe it was given as a gift or something.
Interesting. So there can be reasons.
Right, there's nuance. But the burden of proof falls on the drawer. They need solid evidence.
High stakes. So let's say the worst happens. The drawer can't provide enough evidence. The court rules against them. What are the consequences?
Well, under the Act, the punishment can be pretty serious. Imprisonment for up to 2 years, a hefty fine, or even both.
Wow. Okay, so it's not just a slap on the wrist.
No, it underscores how seriously India takes financial accountability. It's a strong deterrent.
Absolutely. It protects people and businesses from those bad checks. This has been incredibly eye-opening. Who knew a deep dive into an 1881 act could be so fascinating?
Right. It just goes to show that even in today's digital age, these foundational laws are still incredibly relevant.
Absolutely. The Negotiable Instruments Act. It's shaping our financial transactions, whether we realize it or not. From those everyday IOUs to complex international deals, it's been there for over a century, evolving with the times.
And it makes you wonder, how will it continue to adapt as technology changes the financial landscape even more?
Right. Will we see new amendments, new rules for digital payments? It's something to think about. For now, keep those deep diver brains engaged, and we'll catch you in our next episode.